Good morning, everyone, and welcome to North Alabama Law Review, presented by Johnston, Weston. Today, we have with us Christopher Weston and Mickey Gentle. Good morning, guys.
Good morning.
Good morning. And thank you guys again for joining us. So today we're going to jump into our trending topic, which is going to be about title theft. We've heard about this in recent news, how people can come in, steal your identity, transfer your home into their name, or also take out mortgages, and you never know it until it's too late. So guys, do you want to give us some insight on title theft and what exactly is title theft to begin with to help our viewers understand a little bit better?
Deed title theft is also called home title fraud, and this can happen whenever someone uses a fake signature, fake notary seal, and creates a fake deed and records that with the probate court. It can also happen in the case of stealing someone's identity to impersonate a homeowner or to claim false heirship. And it can also take place when someone fraudulently transfers property to a holding company and then rapidly sells it to a third party.
Okay. And then when it comes to title theft, it sounds like it could be something so small and subtle that could turn into a big deal.
Yes, often victims don't realize what happened until it's just about too late, and they realize that their home is on foreclosure or they have had it sold out from under them.
Gotcha. And, you know, we hear about this happening more and more throughout the country. You know, it seems like it's turning into something that's more widespread and happening more and more often.
Yes, last year the FBI reported about 9,000 real estate fraud complaints, and about 44% of that was senior citizen victims.
Oh, wow. Definitely, yeah, it definitely hit the elderly for sure. It seems to be a concern with that. So what can be done about the victims of title fraud, and what can we do to help protect or guarantee that the title hasn't already been transferred?
There are civil remedies monetarily and for the reversal of the fraudulent transaction, or the victim can seek criminal prosecution under the theft of property statute, which is in Alabama a felony. Or at least in this particular case, it's a felony.
Okay. Well, how exactly can we go about to check to see if our title has been stolen? We do know that the tax assessor here locally does have procedures in place, but for someone who is in a county where they cannot verify that, you know, title hasn't been accidentally transferred, how can they go about just making sure that they're protected, making sure it hasn't already happened to them?
The probate court in Madison County has partnered with the tax assessor's court, the tax assessor's office, to create a property change notification system. That system is set up to alert property owners when something like this takes place through email if a deed is filed in the probate court of Madison County.
Okay. Well, thank you. Thank you. So guys, if you are in Madison County, let's go ahead and set up to get those property alerts to make sure that this doesn't happen to you. And if it does happen, reach out to an attorney such as our law firm, and we would definitely be able to assist you in getting that remedy. Chris, do you have anything to add?
I do. So, you know, we talk about on the show quite a bit, especially in the contract context, of things like notice, of giving notice to others. Well, what you have to understand is when it comes to government offices like the probate office, you know, that is seen as, if that is filed, as putting the world on notice in a lot of instances. Mm-hmm. And so that's where you kind of walk into this, not gray area right off the bat, but if you let it sit for too long. And so, you know, the courts expect you, the law expects you to keep an eye on your property, your real property, your personal property. There are some duties there, generally through case law and certainly through common law, for you to be aware of what is going on with your property, to basically check it every now and again. There is no law that I've seen that requires you to check it as far as the probate records. Like you are not forced to go down and check, you know, the status of your deed. But if something has been sitting in the probate office long enough and you do not realize that it is there, you can be held as, you know, you should have known. And so, you know, you'll see this a lot of times in law, that someone knew or should have known. So you'll see this in something like adverse possession, to where like if you let a deed sit there for 20 years or 10 years or 15 years, you know, you can be walking into certain defenses, such as if someone takes a false mortgage out on your property or fraudulently transfers it, and you go through after the fact and say, well, you know, this is fraudulent, this should not have happened, this is inappropriate, someone's been sneaky and done something bad. You run into a problem where, you know, one of the defenses against somebody who was not involved in the fraud, they may say, well, we are an innocent third party, and you let this sit when it was on notice for the quote unquote world to see at the probate office, and this involved your property. Why are you not staying apprised of the status of your property? And so while that will not work unless the fraudster gets away with the fraud, that won't work as a defense for someone who has committed fraud. But again, in the terms of mortgages, in the terms of liens, in the terms of third parties who are not a part of the fraud and are not the property owner, who have relied on things, the longer you let it sit, the more likely they may be able to press certain defenses, things like adverse possession, because, you know, one of the open and obvious qualifiers for that, what's called laches. So laches meaning, well, you should have known about it, or you did know about it and you sat on it having known about it for a long period of time, and it's going to cause damage to somebody else due to your negligence. And so understand it's that defense is that if someone has done something wrong to you, in certain circumstances, if you are just absolutely not involved in any way, shape, or form, you can be seen, practically speaking, as having been negligent when it comes to your property. And while that's not going to punish you, it may not undo a third party who reasonably relied on whatever that fraud is. Now, it takes quite a bit to get to that point. I mean, that's not something that you necessarily, oh, the fraud just happened, I caught it in 6 months, oh no, they're gonna have a defense. No, it's not the way that works. But it's if you literally are negligent with regards to your property, or you are negligent or basically just do not pay attention to what the status of your assets are, and it goes on for long enough and it's gonna hurt somebody else who had nothing to do with it, you can be seen as not so much liable, but somewhat negligent. And so you have to be careful of that. And that's why our office, and a few others I'm sure, started to offer that service of a check. And it's easy to do. It's relatively inexpensive, but it is something where you have now taken a reasonable step to try to make sure that fraud has not been done upon you. Likewise is with any other type of fraud, you need to be aware that it gets more sophisticated as time goes on. You know, the people who are committing this kind of fraud, you know, they do get more sophisticated. And you are dealing a lot of times in this type of fraud with family members or people that are close to you. That's how they get your address or your property description or whatever it happens to be. Or they think it should have been some way, and so they will fill out paperwork where it's like, this is how it should have been, so I'm just going to go ahead and proactively make it that way. Mm-hmm. And it would shock you to realize how many times they feel justified in doing these things, even though it's completely illegal. And so, you know, be aware that, you know, again, your personal information, a little bit of knowledge and notice goes a long way. And so, you know, being aware of the status of your property, checking it occasionally to make sure nothing has changed, you know, looking into anything that appears wrong or incorrect in any of your paperwork is always a good idea, because just like the courts look at doing nothing disfavorably, trying to do something, trying to be proactive, trying to stay in front of it, the courts look very favorably on. And so, you know, that's the biggest thing with fraud is that, especially this type of fraud, and that's why this type of fraud is so scary, is because they are doing fraud in such a way that most people don't think to go look at their deed on a regular basis. It's at the probate office, you're done with it. You know, it's not something you normally think to do. Whereas like your phone, your credit card, something like that, you do check to make sure it's still in your wallet on a regular basis. Mm-hmm. People don't do that with their deeds. And because for a long time, everything had to be wet signature. There was, again, information technology changing the way that it does, is that you had this whole, these barriers that existed to prevent this, because again, someone would have to show up, a notary would have to take down. There's a lot of that. With information, with technology, fraud becomes easier in some ways, but also easier to catch. But that being said, is the reason it's so scary is because it is technically a public record that is out there for the public to see, including you, but it is not something that people in the past have generally gone down and checked their deed on a regular basis. So you're getting a practical loophole, and it is being exploited. So just like anything else with the law, people often ask, why is there so much law? Why are all these little nuances exist in law? Is because as time goes on, a hole is, seen, created, recognized, and then we come in and we fill that hole. And this is one of those times. And so, again, be very careful with your personal information. Be aware of that the probate office is a public record office. And so the things there are seen as public records. And be proactive to make certain that if you've bought something new, if something has changed, if, any kind of major life circumstance that might involve your property, someone passing, someone ill, you yourself traveling, just be proactive, take an action to try to make certain that you are in fact correct on what you believe about the status of your property. Yeah.
I think we all wonder how it can be a problem, because like you said, when we get our deed recorded, it is kind of you leave it recorded in probate and you never think to check the status on it because you're relying on, the government entity to have a procedure to make sure, theft doesn't occur. But one of the things you mentioned that I think could really resonate in our Huntsville area is just staying on top of it and doing your due diligence, because we know with the market that we're having, a whole bunch of out-of-towners coming and buying property as investment properties. They're not local people, so they're not aware if these things happen immediately like someone locally would be able to do. So definitely, I think it's a topic that could resonate with the local investors that are from out of town that just may need that peace of mind that their property is in fact in their name and nothing outside of what they have approved or done themselves is being done with the property. So if you do find that, definitely contact our law firm and we'll be able to assist you with that.
That's also something, if you are investing as a business, where a GC can take care of you on, that entire avenue of issues. That's something we check when you come in. We'll check status of deeds, we'll check status of your paperwork, we'll make sure everything's filed correctly. And that is something that we absolutely do at our firm, and there are other firms that do it as well, but that is where in previous episodes we've discussed having a general counsel. If you are investing out of state, it is very, very likely that you will benefit from a GC if you're doing it at any kind of volume whatsoever. And Shauna, like you stated, that it's one of those things where, there are processes in place, especially our probate office here in Madison County. They are very, very careful. But what happens is, when you're dealing with people who are going to be fraudulent, they learn those systems oftentimes, or they have somebody who does. Or like I said, it's a close family member or some way where there is no way for the probate office to be able to check or verify because of the fact that it is somebody close, somebody who knows the signature or has a notary or, knows, what needs to be filed in the appropriate way. And so they learn ways to circumvent those checks. And of course, as they're, found, they are closed immediately, and there are major penalties. So you even mentioned criminal charge, or Mickey, I'm sorry, you mentioned criminal charge. If they are caught, that can absolutely be a criminal penalty, and a major one. I mean, that is a significant felony, especially with the value and as well as the intent that exists there. Because to commit fraud, you have to prove intent. And honestly, it's not all that hard to do when somebody has forged a document. Now, proving it is forged is sometimes a different matter, but there are ways to do it.
All right. Thank you guys, and I hope you guys have a good takeaway on that. We do want to jump into some questions that you guys have submitted. So Chris, let's throw this first question at you if you don't mind.
Yep.
So if you let someone use your credit card to pay for items and they tell you that they would pay you back but don't, can you do anything about that?
Yes. Short answer is yes, you absolutely can. That can be a monies owed claim. That can be, which is different than a breach of contract claim or like on a loan. Monies owed claim is a very, very, very old type of claim, but it does exist for when you basically give somebody money for a purpose and they know they're supposed to give it back. That can also fall under misrepresentation. That can fall under, deceit, fraud, suppression. So you have a series of claims when you're dealing with somebody who has promised to pay something back. Now, you do have to be careful because, again, any kind of loan can trigger what's called the statute of frauds. Okay, so I wouldn't give somebody, a limitless credit card and say, okay, pay me back when you can. You can run into problems with that because, again, knowledge, notice, specificity, and getting it in writing. So, those of you at home, I am sure can take a look at the previous episodes here and see that there is a running theme throughout all of these, and that's because there is one throughout most of the law. Again, knowledge, notice, put it in writing, and have an understanding of the terms, because essentially what you are dealing with, if you've handed somebody a credit card and said, here, you can use X amount of dollars off of it, and you promise to pay me back, is you've entered into a contract, okay? And depending on how much you've lent, the circumstances of promising that, repayment, you can run into certain statute of frauds issues. However, there are absolutely exceptions, and some of those are monies owed claims, they are misrepresentation claims, they are fraud claims, they are suppression, deceit, sometimes conversion claims, and also unjust enrichment, which many times will fall outside the statute of frauds. And then again, if it's a low enough amount, again, you can run into equity claims as well. And so there are many things that you can do. Again, I don't know who asked this question, but I will tell you, there are many things that you can do if you have lent someone your credit card and they have refused to pay it back. Now, because you gave them permission, it's not going to be a criminal charge, okay? So if someone just takes your credit or debit card, uses it without your permission, that's a felony. That's fraudulent use of a debit and or credit card, okay? That's a crime. And now you have restitution that can be charged in that as well. And that restitution, that's where the state, they press criminal charges as part of any sentence or as part of any plea agreement, they will require it be paid back. But because you gave them permission, it puts it into the civil realm, okay? So generally speaking, if you're lending someone your credit card, which, we all do, if someone's gonna go buy lunch or something like that, it's not really a great idea, but we all do it. Make certain that, it's a small amount, make certain it's very clear, make sure you can prove through witnesses, through something, that they promised to pay it back so that you have the proof. Because again, it's not just what happened, it's what you can prove, okay? And you do not want to get into a he said, she said, or hearsay-based argument in court. But usually in the amounts you're talking about with, lending someone a credit card, it's going to be a small claims case. So the rules of evidence are very much loosened. The judges are, supposed to give a lot of leeway in that. So if it's less than $6,000, well, first off, don't even approach that cap, lending someone your credit card without getting it in writing, okay? Just do not do that. But if it's small claims amount, understand, yes, there are absolutely civil claims out there and you can collect on your money. But last thing I'll say about that is just remember, if you're lending someone money because they just don't have anything at all, you can get a judgment, but that doesn't always mean you can collect upon it. That is a very different thing. So yes, there are legal things you can do. Yes, you can prevail. But if they don't have anything when you lent it to them and they don't have anything when you get a judgment, getting your money back is, again, going to be a difficult situation. But judgments are good for 10 years. So, yes, there are legal remedies.
Thank you for that. Mickey, I'm going to throw a question your way this time. So this person has asked if their Commonwealth partner is entitled to any of their personal savings accounts.
I think there may be a mix-up of the wording there. I don't know of anything in Alabama that would constitute being a Commonwealth partner. It sounds like the question is asking about a common law marriage, and if that's what is meant, I can explain that. Common law marriages in Alabama were allowed at one point if it could be demonstrated that the parties had cohabitated with one another, they had the present intent to be married to one another, they held themselves out to be married to one another, and they had the ability at that time to enter into the marriage contract. Now, those marriages were considered to be just as valid as if you had a ceremony where you had someone authorized to perform the ceremony and pronounce the people husband and wife. And so that was actually abolished in 2017, such that any attempted common law marriage that took place from 2017 forward would not be recognized as a valid marriage. But any common law marriage created prior to 2017 would still be recognized as a valid marriage up to even through today. That being said, in any marriage at all, the state of Alabama is what's called an equitable distribution state, meaning a fair distribution of the marital assets. And so in any marriage at all, if the particular bank account can be considered a marital asset, then it is what we call subject to distribution. Now, that doesn't necessarily mean that the account would be distributed in whole or in part to the other spouse, but it does mean that it is subject to that distribution. And if the judge feels like that is a fair thing to do, that judge can actually distribute that in whole or in part to the other spouse.
Okay, and still talking about common law or commonwealth marriages, if you have children born of that marriage, what is decided with custody if you were to separate?
Custody in any marriage, be it common law or ceremonious or otherwise, is determined by the courts as they are asked to do so. That might be determined by virtue of an agreement between the parties. That might be determined by virtue of a trial and the judge decides one way or the other. In a case of a divorce, whether it's dissolving a common law marriage or any other sort of marriage, or in the case even where the couple has never been married to one another, custody is determined by the best interest of the children, because that is what we call an initial custody determination, because there's never been a determination of custody before, so that would be the initial custody determination, and ultimately that is governed by what the judge feels like the best interests of the children are.
Okay. Thank you for that. It sounds like it's essentially you have to go through the same proceedings as if you were going through an actual divorce in that case.
Yes, because common law marriages and other sorts of marriages are considered equally valid. You're just as married to one another in a common law marriage as you would be in a ceremonious marriage.
Gotcha. Good takeaway on that. All right, we have one last question for today. Chris, I'm going to throw this your way if you don't mind. Mm-hmm. So the last question is, who holds cemeteries accountable?
Oh, whoever sent that question in, I'd like to say that's a good question. That is a much broader question than I think people realize, because in anything dealing with public health, okay, and cemeteries will definitely qualify as having a lot of health implications, a lot of emotional implications, a lot of contractual implications, because again, you're paying for that service. It's very broad. And so the question of who holds someone accountable, especially in a circumstance that is, dealing with cemeteries or, basically anything that can affect health or affect, the body of others of the deceased, it's going to depend on what you're talking about. So, we'll see this quite often where it's if you're dealing with, you bought one plot and then they don't have that plot available, even though you bought that, like they had a mistake or something along those lines. Well, that's going to be a civil lawsuit. Okay. That is something where you are allowed to sue for the breach of the contract because you bought a certain space, a certain little piece of land there. And unfortunately, we have seen this happen, and then they gave it away or made a mistake. That's going to be more your breach of contract type of case where we contracted for this. We said, it was going to be this specific spot, and now you have given that away, lost that, something happened. If you're dealing with something with the way that they are handling the bodies, a lot of times that's going to be a state or a municipal code. Okay, and so that can be a complaint to that agency, or that can be a violation of the law many times. And so that can be to a specific Department of Health, a Department of Public Safety, various departments throughout the state, county, and city, just kind of depending on what the issue is. On the other hand, if they are doing something, criminal, such as, and unfortunately this does happen, not so much anymore, but we've seen the movies, where a body is stolen or traded or sold or not embalmed properly or some other type of fraudulence to save money or make money from the deceased. Well, that can be a crime, and that is going to be the state of Alabama. That is, I can't think of anything that would be a misdemeanor on that along those lines. Maybe there is one, but I've not seen it. Where that's going to be a felony, and that's going to be the state of Alabama where they are arrested, and it goes forward as a criminal action. And so it is very case by case specific because of the interplay among the different parts of what a cemetery does. Okay, from storing bodies to selling plots to, literally keeping security, if that is part of your agreement or not. And so thank you all for joining us.
Thank you for that. And yes, thank you guys for joining into North Alabama Law Review. We do look forward to you tuning in next Sunday morning. If you have any legal questions you would like to submit, please email them to us at legalhelp@jmmtlawfirm.com. Thank you guys again and have a great day.
Thank you. Pleasure.
Thank you.